Okay, so then good morning, everyone. Once again, today's Thursday, October 8th, 2020. Time is 9:04 a.m. Officially calling this meeting to order, attending Commissioners Duncan Brooks and Filios. And I'm going to ask our Deputy Civil Prosecuting Attorney, Pat Braden, please lead us in the pledge. Pat.
That would be an honor. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everyone. Okay, before we go any further, and my opening remarks, I really don't have any, except to ask my co-commissioners, do we have any potential conflicts of interest?
Nope.
Hearing none. Moving on, any changes to the agenda? Hearing none, okay. And so what we're going to do is move on to what is considered deliberations. Is Leanna here? I thought she wanted to say something. I guess not, okay. I see some signs where, it's your First Amendment right, please just don't wave them at us. It could be rather distracting. And before I go any further, what I'd like to do is ask Director Callahan to share a few words with us. David Callahan leads our community development organization, which is the group that basically reviews all permit applications, makes their recommendation, and brings it forth through the hearing examiner and eventually to us, the BOCC. David, please.
Thank you, Mr. Chairman, and good morning, everyone. In the way of first things first, let me please just say, I don't normally presume to sit with the board. We are doing this because I have learned recently that our Zoom meetings have not been entirely audible, meaning that the commissioners' comments haven't been getting caught on microphone, and so people that are Zooming in can't hear. So working with our IT staff, we've set up this new process whereby I'm here only so that I can be picked up on a usual microphone that goes throughout here, but also a microphone immediately in front of Chairman Filios, which connects to Zoom. And so this is merely just a technical matter for the process to work, I hope, smoothly. A second issue or important thing to take note is these are deliberations for this CUP, which is our usual customary process. Deliberations do not allow for the audience to participate. This is between staff and the board. The reason, again, that I've set this up as a Zoom meeting, and of course anyone in the audience is welcome to attend and listen to the board, but I've set it up as a Zoom because we've had such an interest on this process that I wanted everyone that had an interest to be able to at least be able to hear from home if that was their prerogative. So that's the setup. I hope that's sufficient for us to move forward into the case. Normally at this time, the staff would talk about what's in front of you, but I would like to intercede because this case is somewhat unusual.
David, would you mention the case number, please, because I neglected to do it.
I don't have it in front of me, but
yeah, I can do it. It's case number CUP, which stands for Conditional Use Permit 0004, Upper Columbia Corporation of Seventh-day Adventist, for a conditional use permit to establish a private school and place of worship located on approximately 10 acres in the agricultural zone. Go right ahead, David.
I will admit to a flaw on my part, a mistake. I should have noticed when this case first started that we as staff needed to review it under our normal regulations, but also under the federal regulations, the Religious Land Use and Institutionalized Persons Act, also known as RLUIPA. I have been aware of RLUIPA since the year 2000 when it was passed by the U.S. Congress. And I have personal experience with it in Colorado, where a jurisdiction I worked with denied a case. We got sued and we lost. So I should have remembered this. I'm sorry I didn't. But when the hearing examiner recommended approval, or denial, excuse me, it became obvious to me that RLUIPA could potentially be an issue here. And so that's why I have put together a memo explaining RLUIPA, how it works, that it is federal law. The board has had it for approximately a week. But it really is the segue for, I would like to be able to hand off to our legal counsel, Pat Braden, here in just a moment, because I'd like for the board to have a full understanding of what RLUIPA means in this particular case. But also I should add that, again, under deliberations, you have 4 options today. You can approve, deny, remand to the hearing examiner, or you could go forward with a public hearing yourself, and we could presumably hear RLUIPA under that. I'll be so bold as to suggest that my opinion is you should remand this back to the hearing examiner, because there's an argument that without the hearing examiner having considered RLUIPA, the case is not properly before you. That's my personal opinion. I'm no attorney. At this time, I'd like to ask our legal counsel to give you his thoughts.
Pat, please.
Well, David must have stayed at a Holiday Inn Express last night because he sure plays an attorney well in this case. And I agree with everything he said so far, including the recommendation to remand the matter to the hearing examiner. That having been said, that should not obligate the hearing examiner to have to take more evidence or testimony. I think she can reconsider the matter under RLUIPA based on the testimony and evidence in the record and that was gathered at the public hearing before the hearing examiner. Now, what RLUIPA says is that no governmental entity, which includes counties, shall impose or implement a land use regulation in a manner that imposes a substantial burden on the religious exercise of a person, including a religious assembly or institution, unless the government demonstrates the imposition of the burden on that person, assembly, or institution is in furtherance of a compelling government interest and is the least restrictive means of furthering that compelling governmental interest. Now, what that language describes is what courts call a strict scrutiny test. And what that is as stated, that the law in question has to be in furtherance of a compelling, not just a rational, there can't be just a rational basis. There can't even be an important governmental interest. It has to be compelling. And the burden in question has to be the least restrictive means of furthering that interest. And I will say, when a strict scrutiny test applies in any given case, it is very difficult to meet that test. Most, I would say almost all situations that come before courts where a strict scrutiny test applies, that the law or regulation fails. So what I'm saying is it does not necessarily mean that the application has to be approved. It could, there are circumstances under which, such an application could be denied, but it better be a dang good reason, and not just the types of reasons that we would normally deny an application on. And so, with that being said, I think the failure, through really no fault of Ms. Woodard, to analyze this in light of RLUIPA is a fatal flaw in the hearing examiner's recommendation that I believe she should have the opportunity to rectify and then give a recommendation based on RLUIPA, our Land Use and Development Code, and the testimony and evidence already in the record.
I'm sorry, Bill, go right ahead.
I agree. I don't think we should deny it, and I don't think we should approve it. I do think we should remand it and let it be discussed in light of what's been brought forth this morning.
Leslie? Commissioner Duncan feels we should remand it back to the hearing examiner, and I concur. So we have three of us recommending that it go back to the hearing examiner for her consideration involving RLUIPA, which is federal law. I guess we need a formal motion, do we not,
I believe
Pat?
Commissioner Duncan has a motion ready.
Okay. Kathy?
Sure. Do you want date certain?
To be determined?
I
David?
think just once the hearing examiner gives her amended recommendation, we can go ahead and schedule it again for deliberations or, possibly consideration of a public hearing if that's requested again.
Pat, just for clarification for everyone's benefit, will the hearing examiner conduct another public hearing? Or is she simply going to?
My recommendation is that she not be required to conduct one.
Okay.
But
May,
But may
yes.
if she so chooses, okay.
Yes.
Fair enough. So I guess we have a motion.
I second the motion. Oh,
No,
Haven't
no, you
made
made it.
one.
oh, I thought you made the motion.
Not yet.
Okay,
Oh, you have it ready.
Yes.
are we ready?
Yes.
Go right ahead.
Go ahead.
I move that we remand case number CUP 19-0004, Upper Columbia Corporation of Seventh-day Adventist, back to the hearing examiner, who may take into account our LUPA or decide to open it up to another public hearing.
Done?
That's fine.
I second the motion. Aye.
Aye.
Aye, and the motion is carried. So case number CUP 19-0004 is hereby remanded to the hearing examiner. So thank you, everyone. I could open it up for public comment. If anybody wishes to speak, you can do that. You've got 3 minutes, strictly enforced. Yes, sir. Please give us your name and address.
My name's Mark Lord. I reside at 12574 North Sunflower Loop in Hayden. The question that I would have before the board would be, and based on the attorney's recommendation, is he's basically saying that the hearing examiner would have the option of making this a public hearing or not. And I think it's unjust not to open it up for public hearing, given the fact that RLUIPA is a new issue on the table. Therefore, I think the public should have equal right to speak with respect to RLUIPA.
Fair enough.
And I would be in favor of a public hearing, no matter what the hearing examiner came back with, whether it's denial again or approval. So,
But in that case,
I
you mean
support that.
before us?
yes,
Yeah,
absolutely.
yeah.
Yeah,
I
so-
think we're all in agreement there.
Yeah, so there'll be a public hearing whether the hearing examiner chooses to have one or not.
Okay, well, I guess the question for you, Pat, is can we require that the hearing examiner hold a public hearing? Or is that basically her call?
Well, the motion that just carried, gave her the option of doing that. If you were inclined to want to require her to do it, then that would require reconsideration of that motion. I personally think to me, it's a purely legal issue, not requiring additional factual, not requiring an additional factual record to be developed. That being said, there certainly isn't any harm in having another public hearing before the hearing examiner.
In expedience sake, to get it before us, because no matter if she denies or approves, it's going to come before us.
Right.
Then I would say don't have another public hearing.
Right.
But comments obviously are accepted by community development. So anybody who wants to review the law and make comments on it can absolutely submit it to community development.
And if the law were that simple, this is what the law says, I don't think I think we'd have a lot of lawyers out of work who wouldn't be arguing about the law in court. So I'd like to hear what people say, whether it's in front of the hearing examiner and/or here. I don't like hearing the same argument over and over, let me put it that way too. That's a waste of everybody's time.
Okay, so in any case, I think we can leave it to the hearing examiner's discretion as to whether she chooses to hold a public hearing or not. In any case, you will have a public hearing before the board. Yes, ma'am. Would you? Yes, please, come forward.
My name is Linda Colessa, and I live directly across the street from this proposal area. And we met with the Seventh-day Adventists yesterday, and they keep wanting to tell us all about their school and their thing. And what we're trying to tell them, I don't care what it is. My property, I look up at the proposed parking lot, and it's not a matter of a school. It's not a matter of a church. This is the federal thing is completely doesn't make any difference to us. We're looking at it strictly from the standpoint of the fact that it is traffic. It is a huge building, 41,000 square feet. It is parking lots. It is lighting, which is totally inappropriate for our area. This is a field with cows on it. It has nothing to do with it being a church or a school. It is strictly inappropriate for this area. It is going to affect our property values. It's going to affect our way of life. It's going to affect the environment. It's going to affect the wildlife. And we are so concerned that our voices are not going to be heard. And you've had 814 people write in saying they do not want that in this area. And we just feel like, are you listening to us? You know, our lives are in your hands, and we don't know what else to do to protect our interests, especially since they already have a facility at the bottom of the hill that they're currently using.
Okay, thank you, ma'am. Appreciate it. No, that's okay. We're a small group. Hold the applause, please. Anyone else, sir? Come forward. Name and address, please.
Jim Chevatoni, 15304 Shenandoah in Hayden, down the road from the proposed site.
Could you speak into the microphone?
Yeah,
please?
Sure.
Or you can.
Jim-
It's flexible. You can pick it up a
Jim
little. bit.
Chevatoni.
There you go.
15304 North Shenandoah Drive in Hayden.
Thank you.
Down the street. I heard this Arupa, I'm not a lawyer, substantial burden. What is so burdensome about finding property in a commercial spot as opposed to agricultural? So I think there's a room for interpretation, and I think you should do a motion to let people have another say, for sure, before, if the verdict is changed. That's, I've lived in 11 states, military and airlines. It's special out there. And this type of activity where someone moves in and expect everybody to change as opposed to assimilating into an environment where their zoning is proper is just something that the people here, they don't like it. Idaho is special. Trust me, 11 states in Europe. I've been on every continent. This place is special. Let's keep it that way. Thank you for your time.
Thank you, sir. Anyone else? Okay, hearing none. Dwayne, please.
Everybody keeps saying they're not a lawyer.
Name and address.
My name is Dwayne Rasmussen, 886 East Dempsey Drive, Hayden, Idaho. Everybody keeps saying they're not a lawyer. I'm not a lawyer either in Idaho, but I am in Washington and the state of Oklahoma. I have had occasion to do a lot of legal thing. I was a lawyer for one of the highest appeal courts in the state of Oklahoma, so I've got a little bit of experience on this. What I would ask is that you consider allowing the parties to brief the issue of RLUIPA before it gets to you, so that you'll have access to that legal information.
Okay, thank you, Dwayne. Anyone else? Ma'am?
Lois Moore, 31048 East Hayden Lake Road, Hayden. The Seventh-day Adventist has a gorgeous facility down there on Lancaster and Government. Why can't they use it? They say that the fees for rechanging everything around so they can have a school are monumental. Well, monumental to build a new building where they would have to change the zoning. So just let them, encourage them to use what they have. They have plenty of property down there. And then we'd have two schools in the same vicinity because that new one is right behind them. Thank you.
Thank you, ma'am. Sir? Good morning.
Keith Wackles, 5723 East Dodd Road. No, I'm not a lawyer. I'm a resident, and I've been living in the area for about 20 years, a little over 20. The reason why we lived there or moved there was to move from the congestion and exactly what is being proposed to put up on that property. My sons are in their 20s, and they're not interested in continuing to live in the area and grow their children in the area because they're seeing the growth. And it's unfortunate. We love the area. It is special. It seems like encroachment. It's rural. I'd like to keep it that way for my family and the people that would like to continue to move there for the right reasons, that it is a very special country. So I thank you for letting me talk.
Thank you, sir. Russ? Oh, okay. All right. That's all right. He can wait.
Hello, my name's Priscilla Zamora.
Just
I'm
pull
a-
right into the
just pull
mic.
the mic over.
Okay.
There you go.
Hello, my name is Priscilla Zamora. I'm a new resident to Idaho. I came from Connecticut, where we also had a very serious zoning issue in our town. It was not a religious group that was proposing to take over a abandoned school in our neighborhood. But it became a very serious, contentious issue, very upsetting for the neighbors. We were accused of and called terrible names to prevent a hospice facility from moving into our neighborhood, a 3-acre zoned neighborhood that was 45 minutes from New York City. My point is that we fought the city council. It was a tremendously expensive endeavor on the neighbors' benefit, and we finally won. And the reason why we won was because the city was trying to break zoning laws to allow this hospice facility to move in. And the reason why we did not want this hospice facility to move in was A, this was zoned residential, strictly residential, and there were plenty of properties in the city of Stamford, Connecticut, large facilities that could have accommodated their beautiful plans for a hospice facility. My question to you is, if this becomes a legal issue, a federal rule to prevent us from stopping this change in our neighborhood, will each of you, and can you each tell me why you would be in favor of breaking zoning laws and not fighting this federal statute? I am not a lawyer, but the city can fight. I did hear in your explanation, sir, about how it would take a monumentous reason for this legal statute to not prevail.
Okay, so let me, we're going to have to move on. So let me try and answer your question. I don't think we can answer your question directly because clearly we don't have a situation before us at the present time.
I understand.
But
don't
you
have the
can look
information.
back at some of the votes that we've cast and find situations where zone changes were requested and see how we individually voted. So that's probably the best response I can give you. Leslie, did you want?
Well, this is not a zone change, it's a conditional use.
It's a conditional use. But
Sorry.
it gives you some indication as to the thought process, and that's true.
Well, my question is, will you, as being our representatives, fight for us? That's what
I
I'd
don't
like to know today. Sir, Mr. Brooks, you seem to be very in favor of this conditional change in the zoning. Can you explain to us exactly why you feel in favor of this?
I think you're way out of line here.
If I'm way out of line, then I
You are.
am
This
way
is
out
not-
of line.
this is
I'm
not a-
sorry if I
this is
did-
not an
if-
interrogation.
Excuse me.
Excuse me,
You
it's-
just
this
told
is
me
not
I
an
was
inter-
way out of line.
This is not an
From
interrogation.
what I
Ma'am,
heard you say earlier was that you were in favor of this change.
I didn't say anything of the sort. I don't know whether you're misrepresenting.
Okay, ma'am.
Here, it doesn't make any difference. This is not the place for a debate or an interrogation like this.
Okay, we need to.
That's fine. If I will go sit down.
Yes,
Thank you very
Thank you.
much.
By the way, how long have you been here?
I've owned the property for almost a year.
Oh, okay. Well, I'm a former
Thank you.
New Englander too. 20 years New Hampshire. Welcome.
Thank you very much.
Okay. Russ, did you want to speak? Just give your name and
One
address,
way or
would
the
you,
other.
please?
Go ahead.
Russell McLean, 2360 East Hayden View Drive. I've gone to every meeting this school has had since the conception. It's been going on for
Excuse
years.
me, Nancy, can you hear us? Can you pick him up? Try to get closer to the mic.
Yeah, okay.
There you go.
They're going to run a tight program. I've looked at the curriculum. I've sat in all their meetings. It's going to be a good school. And it's going to have respectful kids, you know. And I think you guys really need to weigh out the benefit and the competition to the public schools, because our public schools have only gotten better with the competition from charter, STEM, and other places. And, you know, those meetings have been going on for almost 7 years, I think. And they got a tight program. And it'll only benefit everybody. And it's something that has to be considered in every decision, the benefits of the impact, not just the negatives.
Thank you, Russ. There was another gentleman who wanted to speak, I believe. Yes, sir.
Good morning, Council. Thank you for the time today. Paul Lawson. I live at 15011 North Boot Hill Road, very close to the conditional use permit application. What I'd like to do is make sure, with regard to the RLUIPA, that input can be given to the legal counsel, because it shows right here in number 4, a poll for conflict of interest. And I think the real point needs to be made. It's not hard. Everybody knows the term follow the money. Okay, we all know who owns the property, and actually both the properties. And this whole movement, it's not about religious freedom or expanding their school or moving. There's plenty of commercial locations that said individuals own already. It's for the development of the Hayden Canyon and the value of the property, and they're doing a swap to do that. And I'd like that to get duly noted in the legal counsel's look at or review of it. It's not a religious freedom issue. It's a money issue. So I just would really like to make sure that everybody here has access, or we can get the contact for the county's legal counsel to bring any of that to light for the review of the RLUIPA.
Yep. And that all goes into the file, and the file is open to all of us, absolutely.
Okay, great. All right. Thank you very much for your time this morning.
Thank you,
everybody,
sir.
for coming out.
Ma'am?
I'm Linda Radigan. I live at 37137 East Hayden Lake Road in Hayden. And when I hear about the CUP, the conditional use permit, versus the zoning, I think it's just semantics. It's just a way to get around the zoning. And many of us have sacrificed for years so we could live out there where the previous commissioners told us in the master plan, I know it's not called the master plan, but that this would be 5-acre parcels. And we need to have you guys comply with what they said that they would do. I mean, we're counting on you to continue on with our way of life that we all love and that you love, I'm sure. Anyway, thank you.
Thank you. Anyone else? Okay, so hearing none, the time is now 9:34 a.m. I'm sorry?
You have one person on Zoom.
Oh, I'm sorry.
They've been trickling down. Is it okay if I ask if?
Yeah,
Mark would
absolutely.
like to- Mark, did you have anything that you wanted to say at this time?
His mic is still muted, see?
And if you're trying to talk, your mic is still muted. Apparently not.
Okay. So with that note, it's now 9:35 a.m. and this meeting is adjourned.
No, it's not. May we please do signings?
Oh, well, no, but the public hearing segment.
That's not a
It
public
wasn't
hearing.
a public.
It's deliberations. I'm
deliberations.
sorry. So the deliberations are concluded. Sorry about that. So we move on to our signing segment. Jeez.
Too
Hickey.
many choices.
If you're ready for a motion.
Yes, I am.
Okay, I move that we execute the order of decision for ordinance number 553 and case number ZON 20-0002. Lauren Webb.
I second the motion. Aye.
Aye.
Aye, and the motion is carried, so we're executing the order of decision for ordinance number 553. In case you folks are interested, what we're doing here is signing the orders, which are decisions that we've made on hearings that came before us in the past.
There's 2 spots, Chris, the purple 2.
Ooh, we got another one. Okay. Right. There's a purple marker.
This one,
Yeah, there you go.
that's it.
Yeah, 2 signings. Did you sign twice?
No. Oh, there it is in the first page. Okay, there you go.
All right, so next, I move we execute the order of decision for ordinance number 554 and case number ZON 20-0003, Hindenburg Living Trust, Dirk Graskamp.
I second the motion. Aye.
Aye.
Aye, motion's carried. We're executing the order of decision for case number ZON 20-0003, which was the Henneberg Living Trust, Dirk Crosscamp, to complete a zone change from rural to commercial of 2 adjoining parcels totaling 17.4 acres.
And I move that we execute the order of decision for case number VAC 20-0001, the Coeur d'Alene Airport Southeast vacation of plat.
I second the motion. Aye.
Aye.
Aye, and the motion is carried, so we're executing the order of decision for the vacation of 20-0001 case. Okay. So that concludes the signing segment of our meeting this morning. Our final segment, which is our business segment, which typically involves community development update. And I see there are no items. Is that correct, Director Callahan?
Nothing at this time.
Okay.
Oh, my God.
So at that note, it is now 9:38 and the meeting is adjourned. Thank you.